Hey, what's up guys? Legal Bro here. We're back today on Attorney Reacts, baby, taking a look at some lawyers that are behaving badly. Let's get into it.
Police just witnessed the driver of this SUV throw a cigarette out the window. Moments later, the driver makes a turn without signaling, then accelerates beyond the speed limit. After officers pulled the vehicle over, they reportedly noticed the odor of alcohol coming from inside. The driver's then removed in order to perform a set of field sobriety tests.
All right, so we got the throwing a cig out the window, turning without signaling, and then obviously speeding. Probably not off to a great start. Obviously, if they smell alcohol in the vehicle, probably gonna have her do a field sobriety test.
What I want you to do is I want you to focus on the tip of my finger. It's gonna move side to side. Focus on it with your eyes and keep your head still, okay?
All right, so first test, if she's had anything to drink, I mean half a drink, she's gonna fail it. Follow the finger, right? Going this way. The police are gonna look when her eyes get to the side of her head if they are twitching. If the eyeball is twitching or moving, they're trained to be able to identify that. I'm not a cop. I don't know how to identify it. But that would be enough to be able to tell because everybody's body reacts the same way. Their eye would be giving off this signal. So whether you're blowing over a .08 or not, that's probably gonna be the first and easiest hurdle for the police to get through would be, the eye test, right? But doesn't necessarily mean that you are over the legal limit.
Picture an imaginary line in front of you. Place your left foot on the imaginary line. Now you're gonna take 9 heel-to-toe steps out along that imaginary line, counting your steps out loud. You can start whenever you're ready. Not gonna be able to do it?
The old Texas two-step, baby, right? Heel to toe, heel to toe. That's going to be tough even if you are sober. If you are drunk or if you are impaired, doing that would be very difficult. My question for this officer would be, obviously we've seen them say strike one. That's probably strike two based off of how she did on the eye test and obviously the heel to toe. Not off to a great start.
Next, I want you to count backward from 54 to 37. Do you understand? Okay, go ahead. Whenever you're ready.
54, 53, 52, 55, 60, 49, 48, 47, 41, 40, 39. Did you say 39 and 37?
37.
Oh, she was so close there. I mean, I'm telling you, I'm watching her count off and I'm like, that's pretty good whether you've been drinking or not. That's pretty good. 54, 53, 52. I mean, that takes some talent. The only giveaway was that she couldn't remember what number to stop at, right? I think all she would have had to have done is just blow right through, say, guys, I can go all day. You want me to get into the negative numbers? We're good to go. Obviously, that's kind of the giveaway. Was it 39, 37? Still tough, right? Even if you're sober, it's like, I can't remember. Did you say 54 to 37? Yeah, it's kind of tough, right? Not good. Not good. Obviously, if she's asking what number to go to, not going to be good.
Okay.
There's strike two.
All I need you to do is wrap your lips around this tube. You're gonna blow through just like this. You don't have anything to tight mouth, right? Can I have to take a look real quick? All right.
So why the officer is saying that, and this makes sense, is that if she has anything in her mouth, it could throw off the reading of the breathalyzer, right? And obviously they are very concerned with that because if this is something that they're using to gauge her ability to drive, they don't want to allow her to drive away if they get a false reading. And similarly, they don't want their case to dissolve if this breaks down. And there are cases out there where guys have been chewing tobacco or they've got a dip in and they don't spit it out, and it comes back that any evidence collected related to this false reading has to get. So what's super interesting about this is we saw that she flicked the cig, right? Was there 20 minutes in between when she flicked the cig and had been smoking and when they do the reading? Because if there isn't, I don't know. It'd be super fascinating to see, what defenses she would have. Maybe the cigarette would cause this reading to be inflated. Maybe it would cause a false reading. I'm not sure. I know that chewing tobacco does. That's why if they see you with chewing tobacco, they would wait after you rinse your mouth out. But something like this,
As they wait for the breathalyzer results, the officer asks the driver a sobering question.
Do you think you should be driving right now? Do you have kids?
I have kids.
If you had your kids in the car, would you be driving right now?
No, I'm not.
Can you read that out loud for me?
And strike 3.
So at this point, I am going to place you under arrest for operating while intoxicated. I'm going to have you turn around, put your hands behind your back, and interlace your fingers.
Sir, are you bringing me to jail?
I am.
What so far has been a pretty typical traffic stop and arrest takes an interesting turn when the driver tries to plead her case.
Is there any way I'm really gonna... I don't drink and drive. I'm running for an office right now.
Okay.
This will me up really bad.
And not just any office. 49-year-old Julie McDonald is a local attorney, and she's running for county circuit court judge. Around 11:45 a.m., McDonald arrives at the police station and tells officers she'd consumed 4 vodka drinks the night before and agrees to another breathalyzer test.
Holy smokes, folks. So obviously I'm not condoning drinking and driving. That's terrible. Obviously, if she was convicted of drinking and driving, she'd deserve it. But when you are interacting with the police, if you don't need to disclose something, why would you disclose it? When she says that she wouldn't be driving if her kids were in the car, she doesn't need to answer those questions, right? Just get, officer, am I being detained? Are we going in, right? We going downtown? We going for the long ride? That's it. Right? We don't need to sit here and say, all right, let's play 50 questions. If your kids were in the car, would you be driving? If Santa Claus was on the moon, it's just crazy. So the fact that she is still talking, yeah, I had this many drinks, I had them last night, I did this, I did that. You don't need to say any of that. Follow the officer's instructions, but you don't need to tell him your life story, throw yourself up a river. They're going to be able to do that without you doing it yourself. Obviously, if she's running for judge, she has, a lot more on the line, which is why she's kind of asking for mercy. Just because she doesn't agree that she wouldn't have her kids in the car, or she doesn't admit to how many drinks she has, doesn't mean that she lacks candor in this situation. She has the same rights that everybody else has, right? She can remain silent, and she doesn't need to self-snitch on herself, even though she's done that. Interesting maneuver. See if it works out.
This one reads .08, which is exactly Michigan's limit and technically considered drunk driving, but also falls within the test's .004 margin of error. McDonald would later plead guilty to careless driving and littering for tossing the cigarette out the car window in exchange for the dismissal of the drunk driving charge. She was required to pay $2,000 in court fees, continue daily testing for alcohol use, and complete 40 days of community service. As for her bid for county circuit court judge, it was a success. But 8 months after she was arrested, Michigan Supreme Court ordered a 45-day unpaid suspension for her misconduct behind the wheel.
Okay, so that's going to be fairly standard. The Supreme Court, right, in any state is the one that governs all of the lawyers in that state. So it's not like she, had this circuit court case and then this appellate court case. I mean, everything that an attorney does misconduct-wise goes in front of the Supreme Court, right? It's brought by their bar organization. So it's not unusual that she would be punished, right? She's punished for 45 days in this case for, this criminal act that she pled guilty to. Obviously, it's unbecoming, right, for even a judge, right, that higher standard, an elected official doing these things. But overall, I think she handled herself really well, even if she did make a very terrible mistake, and obviously she knows that.
Next, we're in Topeka, Kansas for a Supreme Court disciplinary hearing for attorney Dennis Hauver. The defense lawyers at the High Court, a year after a state review panel called for his disbarment, citing, among other things, professional incompetence in his handling of a capital murder case. Laying out the details of the panel's findings is the deputy disciplinary administrator for the courts. He claims Hauver had no business taking on a capital murder case to begin with.
Respondent only experience in a murder case was some 20 years prior to that. That was not a capital case. He really had no idea of the law of capital murder trial proceedings.
And what is your recommendation for what we should do today?
My recommendation is that you approve the discipline of disbarment.
Yikes, not good, folks. When an attorney has committed some act that the bar or governing body of their state believes is unbecoming or violates their rules, then they have different punishments, right? Some of the punishments could be you get admonished in that your bar journal has or newspaper, whatever it is. Then there are more severe ones, right? They might suspend you for a year, in which case that suspension, you'd have to retake the bar exam, you'd have to reapply to be a lawyer. The most severe would be like the F. Lee Bailey type, yep, we are going to make sure that you never practice law again. Super severe. One of the best ways that you could be disbarred is by messing with your trust account, so stealing money from clients. You all remember what was going on out on the West Coast there with Erica Jane and Tom Girardi, right? Stealing money from widows and orphans. Not good. This is similar, right? Having a client who is potentially going to get death is a very, very serious case. It should not be taken lightly. You have to have a level of expertise that goes into that type of case that goes even beyond criminal defense work. This isn't something to be taken lightly. And obviously, if the lawyer did such a bad job as they claim and his client gets death, I could see why they think, okay, disbarment may be warranted.
With serious allegations leveled against him, and with his law license on the line, it is imperative for Hauber to present a professional rebuttal to the Supreme Court.
That takes a level of courage, folks. So anybody that does any sort of appellate work, I commend you. I can't imagine going in front of the Supreme Court and arguing that you are pro se and you are going to argue to keep your law license. That in and of itself would be a feat, because that has got to be extremely stressful. Taking it up one notch, dressing as Thomas Jefferson, absolutely unbelievable. And I don't mean unbelievable like, wow, that's a great idea. The next time I go and do an oral argument before the court, I'm going to dress up. Not good. If this entire thing is about credibility, I don't know what on earth you think.
That's right, donning a powdered wig, an 18th century suit, and white stockings.
Oh my God, this is incredible.
Now argue his professional competency in the state's top court.
I wore this outfit because today the United States Constitution protects my rights to try the case as my client and I agreed.
The case in question was the capital murder trial of Philip Cheatham. The 30-year-old was charged with shooting 2 women to death and attempting to kill another during a home invasion. Cheatham had a long criminal history, including a previous manslaughter conviction for shooting and killing a man during a drug deal. Most defense attorneys would not want to introduce that history at trial, but clearly Hauber is not most lawyers.
Client was a criminal for a living.
While possibly an unorthodox defense strategy, Hauber claims it was not incompetent.
Don't forget, Philip Cheatham didn't complain about my performance or conduct. You did.
The jury ultimately found Philip Cheatham guilty of the murders and sentenced him to death.
So obviously, Philip Cheatham is probably not a very nice dude. He probably was going to get convicted, right, of something. Whether or not he gets the death penalty, we're not sure. But he still deserves, because we're in America, he still deserves competent counsel and representation, and that's the court's point here. And although TJ or Thomas Jefferson's oral argument to the court is, look, court, I can do whatever I want to do when representing my client. And oh, by the way, my client didn't even give a hoot. He doesn't care what I set up there. You guys do. Fair enough. Obviously, there are different strategies and different types of attorneys and ways to present a case. But if he's before the court and they believe that his strategy was so incompetent as to guarantee that his client would be convicted and sentenced to death, probably not a worthy strategy. But he's got a lot more nuts than me. I'm not taking a capital murder case. Not a chance.
Following the hearing, the Kansas Supreme Court upheld the state panel's findings and disbarred Kenneth Hauber for what they called, quote, inexplicable incompetence.
If you want to see more Legal Bro videos, go ahead and take a look at my page. We're covering all different topics. I'm a class action lawyer, so I love those types of cases. But if there's anything else that you want us to cover, Attorney Reacts, always bringing it to the people. Legal Bro, out.